James Daly.
Thank you very much indeed, Mr. Deputy Speaker. I wanted to touch on some legal points. Sadly, I am a lawyer, or perhaps happily I am a lawyer, and I wouldn't touch this civil litigation with a 50-foot beanpole. So, what I would say though is I think there is a fundamental misunderstanding of some of the points that have been raised. The first point, one of the objections that's put forward by members on the other side is the issue of principle. Well, there is no objection to this on principle because the Honourable Lady, the Shadow Secretary of State, and also the member who previously spoke have both agreed that the principle behind this, the reason why this has been put into law, is good. The defence of freedom of speech is an excellent concept, and how anybody can object to that is beyond me. And so when that argument is overcome, we then come back to, well, it's already on the statute book, so we don't really need it. But that's not a defence to not supporting what we're putting forward in respect of this. Two examples have been given of abhorrent behaviour, abhorrent statements that could be made on a university campus, which would mean that a university may well open itself up to litigation. Well, the first one is Holocaust denial, and clearly none of us want to hear Holocaust deniers or see them on university campuses. The Secretary of State at that dispatch box today, and on a previous occasion before this House, and in any number of interviews, which I could read out verbatim here, has said quite clearly and categorically, this cannot be used to justify the spread of Holocaust denial or any other form of anti-Semitism on our university campuses. And when a court interprets this legislation, it interprets the intention of Parliament. The intention of Parliament is clear. The Secretary of State has said that no university can justify the welcoming on to its campus or allowing onto its campus anybody who is going to talk about Holocaust denial. It is absolutely... No, I won't give way. The second point... Absolutely not. There is no dispute in respect of it. It is the specific intent of this legislation to ensure that Holocaust denial is not to be covered by the free speech recommendations within this. The second point... No, I won't give way. The second point is anti-vaxxers. Now, anti-vaxxers, I disagree with anti-vaxxers, but the point of this legislation is the only other example that could be put forward by members opposite is... Do we seriously believe that anti-vaxxers should be discriminated to the extent of banned from state premises, banned from education establishments? What this bill does allow, which nobody's mentioned, is that universities are under a duty to use what efforts are reasonably practicable to ensure that free speech happens. Now, if we were to look, it may well then support the legislation if that's the case. The point being, therefore, in respect of anti-vaxxers, if it is reasonable, if the legal duty upon the university is to put in place what steps are reasonably practicable, do we think it's a better option for university vice-chancellors to put forward other speakers and insist that other speakers put forward the other side of the argument? Or do we just simply say, or allow university vice-chancellors or whoever makes decisions, because we don't like your view, we're just going to banish you and not allow you to speak? And what this debate is really about, Mr. Deputy Speaker, it is about the regulation of legal behaviour. Because the law exists, the Public Order Act, the Equalities Act, prevent legislation, all sorts of other legislation exist because this House has voted at different times to say that certain behaviour is not is against the law and that the authorities should act in respect of that. I listened to the very, very powerful speech from the member for the member for Birmingham regarding the appalling incidents of sexual harm on campuses, but that is an utter indictment of universities. That is not a reason to allow and to see that we should have faith in universities to regulate them. If they cannot regulate the most serious sexual complaints, why should we have any faith in them regulating the ability of individuals to practice freedom of speech, which is a basic right? We cannot confuse freedom of speech. If there are allegations of serious sexual assault, we should be asking our police, why are you not investigating these things? In Greater Manchester, where we are run by the Mayor of Greater Manchester, we have a conviction or a charge rate of about 1% for serious sexual offences. Are we seriously arguing that that should be taken away? That appalling record of the Mayor of Greater Manchester in respect of serious sexual offences should be taken away, and we should be concentrating on whether university professors are regulating serious criminal behaviour? It is a ludicrous point of view. So we come down to this. This whole debate comes down to a central fact. And I thought it was quite dystopian by some of the comments that were mentioned opposite, in that we should have a debate about what we as individuals think is right or wrong to say on a university campus. How utterly ludicrous is that? If we feel that something is not to be said on a university campus, that if it is harmful or makes a person feel in fear of their safety, the Section 5 of the Public Order Act, Mr Deputy Speaker, makes an offence to cause somebody harassment, alarm or distress. That's all you need to do to prove an offence under the Public Order Act. It is for the law to sanction people's behaviour, not individuals, and certainly not those institutions which are the beneficiaries of taxpayers' money. This is a good bill, it's a manifesto commitment, and it's a commitment to free speech we should all celebrate and support.